When does sending legal papers by email count as proper notice? The Supreme Court has now answered that in the Fuld v. Palestine Liberation Organization case. A family in Washington, D.C. sued the PLO over the tragic death of a loved one in a terror attack. They tried handing the complaint to the PLO's U.S. office, but came up empty. So the judge said, okay, you can mail it and even email it to their New York representative. The PLO argued that wasn't a real way to serve papers, but the Supreme Court disagreed. It said that under the law governing suits against foreign entities, courts can allow these alternate methods when personal service isn't possible. This ruling sends the case back to lower court and means the family's lawsuit can move forward. It also sheds light on how judges balance the right to fair notice against victims' need for access to justice. Stay with us. Coming up, we'll break down what this decision means for future cases and everyday Americans. 9 Robes uses non-partisan everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. American citizens and their estates who were injured or killed in terrorist attacks abroad sued the Palestine Liberation Organization, PLO, and Palestinian Authority, PA, under the Anti-Terrorism Act of 1990. After winning jury verdicts worth over $650 million in one case, the Second Circuit Court of Appeals overturned these victories, ruling that U.S. courts lacked personal jurisdiction over these organizations because their alleged support for terrorism occurred overseas and didn't create sufficient connection to the United States. In response, Congress passed the Promoting Security and Justice for Victims of Terrorism Act of 2019, PSJVTA. This law specifically names the PA and PLO and establishes that they are considered to have consented to U.S. court jurisdiction in terrorism cases if they either 1. Pay salaries or death benefits to convicted terrorists or their families, or 2. Maintain any offices, facilities, or conduct any activities in the United States. Lower courts found this law unconstitutional under the Fifth Amendment's Due Process Clause, but the Supreme Court has now reversed that decision. Chief Justice Roberts, writing for a unanimous court in judgment, made 3 key rulings. First, the Fifth Amendment's Due Process Clause, which applies to federal power, doesn't incorporate the same minimum contacts test used for state courts under the 14th Amendment. This is because the 14th Amendment concerns relationships between states, while the Fifth Amendment deals with federal authority, which can extend beyond U.S. borders. Second, Congress acted within its constitutional authority when creating the PSJVTA, which links jurisdiction over the PLO and PA to conduct that meaningfully relates to the United States and involves critical foreign policy decisions made by the political branches of government. Third, even if applying a reasonableness standard from 14th Amendment cases, the PSJVTA easily passes constitutional muster. The court noted the strong interest of American victims in having a U.S. forum, the nation's compelling interest in fighting terrorism, and the absence of any unfair burden on the defendants. The court reversed the lower court's decision and sent the cases back for further proceedings. Justice Thomas, joined partly by Justice Gorsuch, agreed with the outcome but offered different reasoning. He argued that the Fifth Amendment, as originally understood, places no territorial limit on Congress's power to extend federal jurisdiction. In his view, the Due Process Clause never imposed substantive restrictions on extraterritorial federal jurisdiction in the first place. The PSJVTA carefully amends the Anti-Terrorism Act's jurisdictional rules in 2 specific ways. First, it targets incentive programs, like salaries paid to terrorists serving prison terms in Israel and benefits paid to families of terrorists killed while carrying out attacks. Congress had previously condemned these payments in the Taylor Force Act. Second, the law subjects the PLO and PA to U.S. court jurisdiction if they maintain any offices, facilities, or physical presence in the United States. This provision builds on existing restrictions on PLO-PA operations on American soil. Importantly, the law applies only to terrorism claims and specifically excludes the Palestinian mission to the United Nations. Unlike broader jurisdictional provisions, Congress crafted the PSJVTA to target two specific non-sovereign organizations already involved in U.S. counterterrorism policy. The law gives clear notice that continuing these specific activities will be treated as consent to being sued in American courts. The statute reflects a careful legislative balance between deterring support for terrorism, respecting diplomatic and foreign policy concerns, and ensuring fairness to defendants who have known connections to the United States. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.